Thank you for coming. Today we're going to review Demurer's and 355C motion. This is the first in the battle ready series that we have. All of these are geared towards preparing us for going to battle. I was contemplating on playing the Conan theme song with the two drums done. I decided not to. I should have maybe. But in this is part one. Part two will be on September 4th, and Amy Myers and Christina Samus will be doing it. And it will be entitled Show Me the Money, Pre-Trial Discovery. And so that's something really to look forward to. That's going to be good. Now, with that being said, today what we're going to do is talk about, for the first Demurer, what is it, how it came about, what it means, how to use it. We're going to go over some examples. I have some hypos here. And what I'm hoping to do is get some audience participation on the hypos. Try not to look ahead too much to see what the answer might be, although I tried not to make the answer too obvious. So that when we're processing and working through it, I think that it's easier to learn from it rather than look at the answer and go, oh, I know that, and not have to struggle through it. So try and work with us on that. And those are for the hypos. And the other thing I wanted to say was, hopefully what we can do is foster what we've been doing in the evening MCLEs. It's kind of an informal thing, whereas you feel comfortable with sharing, because it's easier and I think better to maybe make a mistake or do something that that might not be right according to the appellate court here in front of your peers instead of in court in front of the bench officer, right? So hopefully we can do that. Having said that, what is a Demurer? Or a motion akin to Demurer? So just starting basically on what a Demurer is, because it's challenging enough to spell it. Looking at the legal definition on law.com, it says it's a written response to a complaint filed in a lawsuit which, in effect, pleads for dismissal on the point that even if the facts alleged in the complaint were true, there's no legal basis for a lawsuit. And the question was, does this exist in dependency court? And the first thing is like, yes. The reason there's a question mark is it didn't before. But as law develops, things change. So with certain cases that have come about, which we will discuss, and Local Rule 7.16, we do have a Demurer, or a motion akin to Demurer, and we have basically a schedule of how to raise that and how to follow through with it. So, in re Fred J is the reason why we have the Demurer in dependency court, and it talked in re Fred J. It talked about another case in re JT, where the petition was demurred to because counsel said that on the grounds that the facts sufficient to constitute a case of action against the appellant did not exist. And the allegation in that particular case, in re JT, was that in part, mother evidences immaturity and demonstrates a lifestyle contrary to the welfare and best interests of said persons, all to such degree as to make her inadequate to the care and supervision of said persons, and that therefore the children are in need of proper and effective parental care and control. So, having read that, if you get a petition that states something like that, how do you feel about that? Do alarm bells start going off? Are you confused? Is that a clear petition for you? No? I see some people shaking their heads no. So the trial court actually, in this case, the trial attorney demurred, and the trial court overruled the mother's demurrer and made conclusory findings according to the appellate court. The appellate court reversed the juvenile court orders with directions to dismiss the petition on the following basis: that the petition first did not state facts required by what is now WIC 332F, which we'll discuss in a moment, with sufficient particularity to support the allegations. And two, did not give appellant meaningful notice of the charges. The court went on to say that appellant was further denied due process of law because trial court's findings were conclusions of law, not findings of fact that apprised appellant of the court's reasoning. So that was in Re JT. And while in Re Fred J was looking at it, the appellate court there said, after diligently examining the statutes governing dependency proceedings, they could not find anyone expressly recognizing the use of a demurrer. And the reason that they give was that juvenile court proceedings apparently do not contemplate written pleadings by the parents or children. So we're going to find ourselves behind the 8 ball for a variety of reasons. This whole court dependency system has been set up for the protection of children. And the protection of children is going to trump a lot of things every single time. And in this particular case, expediency and speed is what the courts have seen dependency court needs, because we need stability and permanency of a child as soon as possible. So that written pleadings weren't really envisioned in the beginning because they wanted to go quickly. So in Re Fred J stated, after observing that due process requires that constitutionally adequate notice be given, and the absence of a procedural device to raise the question of adequacy creates an awkward hiatus between theory and practice. I kind of like that, awkward hiatus between theory and practice. Thank you, appellate court. The court recognized that the juvenile court has inherent power to entertain a pre-hearing challenge to the petition, sufficiency by, say it with me, a motion akin to a demurrer. Thank you for humoring me. I appreciate it. So parties should have the opportunity to test the sufficiency of a petition in the trial court rather than reserving that question for the Court of Appeal. Before, it would be, you don't raise it until the Court of Appeal. You can raise it first at the Court of Appeal. But by that time, depending on how many years have gone by, imagine the child's already in a home, and a lot of it is about the best interest of the child. So if the child's been placed in the home of a caregiver for many years and is bonded with the caregiver, has not had the opportunity to reunify with the parent hasn't been visiting, even if maybe the department blew it and trial counsel blew that issue, do you think the appellate court is going to order any change to the child? Probably not. So we really have to be careful with that. Now, just to talk about in Re Fred J a bit. It alleged that the mother failed to adhere to the following juvenile court orders of March 18, 1977. And this was not a 300 petition. This was, I believe, a 387 petition. So the mother was getting services, and they filed this to remove the child. And it stated that mother failed to provide a stable and adequate environment for the minors, to adequately cooperate with school officials, to cooperate with the placement social worker in the following areas, including 1, the mother did not seek or receive approval of the worker in the changes of residences, and 2, the mother has prevented any meaningful contact between placement social worker and the minors. The pleading went on to list that the mother failed to provide appropriate mental health counseling for the minors and to undergo appropriate mental health counseling in order to understand her effect on the children. And that finally, the minors are unable to experience an appropriate emotional, education, and psychological environment while in the mother's home. So, before turning the page, what do you think about this language? So, why are we going on?
Well, there's no direct allegations of harm to the child. They're missing school. They're not meeting educational goals. They're acting out because they're not getting caught. There's nothing. It's just kind of piss off the social worker.
Right.
Like cooperating with them, and that's the main one on that.
It sounds like it, right? It sounds like the social worker's pissed that mom's not adequately cooperating, and he or she is fed up. Okay, well, I'd like you to turn the page. And it states that the Demurer fails in this case. Now, this is an interesting one in that In Re Fred J, along with In Re Jessica C later on, recognizes that the petitions are written by lay people. They're written by social workers. They're not written by attorneys. And that it goes on to say, in Re Jessica C, we'll talk about that later, the appellate court says, normally we wouldn't, someone who's not a lawyer cannot write petitions. They can't write allegations. They can't file allegations. But in this particular case, again, because of child safety, everything is practically thrown to the wind. Expediency is important. There's an emergency, that something might happen to the child, so we don't have time to wait for lawyers to write these. We're going to let social workers write these. And because social workers are going to write these petitions, they're not going to be exact, they're not going to be legally correct, they're not going to put all the facts in it, so that it goes on to state that the petition contains too many adjectives which may convert factual matter into opinion. Example, meaningful, appropriate. And while the court states the petition includes a mixture of factual allegations, conclusory descriptions, and conclusory opinions of the petitioner, it was sufficient because, that last bullet point at the bottom, it provided meaningful notice to mother, adequately communicating the department's concerns to her. Okay, so just to show that we're not always right, we're not always wrong, Justice Carlton supplied a written dissent. So reasonable minds can differ on this instance. So if you're kind of waffling about whether you should do it or not do it, and people are saying, oh, you're ridiculous, no one follows Demers, there may be a basis. Don't let people bully you out of it. And this justice said that the petition provided no meaningful notice of what facts the mother was required to meet at trial, that the petition was an incongruous melange of factual allegations, conclusory descriptions, opinion, and pejorative comment. And the justice had a point when he talks about, or actually he or she, I'm not sure, the pejorative nature of appropriate mental health counseling when the mother took child to 2 private psychiatrists instead of following the social worker's advice for taking children to children's mental health services. Additionally, the justice said, no assertion that mother failed to cooperate with school officials, but instead that she failed to adequately cooperate with school officials, which is an opinion. So what we can see here is that there is a differing, there could be different opinions with the petition. That a petition that is written is given a lot of leeway because of who's writing it. The onus is on the lawyer, the attorney, to raise any of these issues because they're best suited. And we're going to talk about when we need to raise these and why. But what I think is really important is, in the dissenting opinion, the justice used some language that is helpful. What's really cool about reading a lot of these appellate decisions is not only are you reading about the issue that you might be working on, but you get all these other ancillary issues that that court had to deal with. And in this particular, and a lot of times it provides you really important language to use, to have in your back pocket, and to just use the reasoning for that. And the justice said here that a dominant parental right to custody of the child pervades our law, and cited the U.S. Supreme Court and said that it is cardinal with us that the custody, care, and nurture of the child reside first with the parents, whose function and freedom include preparation for obligations. The state can't neither supply nor hinder. We all see what a good job the department does with the kids in foster care. Not so good. So really, the best is to keep the parents when we can. And the justice recognized that the statutory recognition that it's improper, it should be improper and ineffective parental care denotes a fairly extremely case. You know, we're not looking for perfect parents here. We might not have the sharpest tool in the shed, but it needs to be fairly extreme before we move children. It's not a social engineering experiment here. We're not placing children with family members that have more money that can put them into summer camp or can take them to the equivalents of Toys R Us every other weekend. And that although a home environment may appear deficient when measured by dominant social economic standards, interposition by the powerful arm of the public authorities may lead to worse consequences. And therefore, to intervene in extreme cases, we must justify the decision with clear and unambiguous factual findings, and the dissenting justice in this case said, that wasn't this. But the justice didn't win the day on this particular one. So, when should you use a demurrer? Now, I want to kind of state that I know we have busy days, and we get, you know, that third petition on the day that we have 4 arguments on our calendar. It's stressful, and you're reading through the petition, you're looking at it really quickly, you're like, Okay, and then you look at the facts kind of briefly, but it behooves you to really listen to your gut. Although the gut doesn't always work with everyone, if something feels wrong, stop and think about it. Because if the petition isn't sufficient, you really need to demur it. And it's not just the petition. We're going to talk about it in a moment. We have a case where the justices have said that a petition does not necessarily need to be regurgitation of the facts. So while the petition may be weak, if the facts in the detention report kind of undergird the allegations, that might be enough. And I'm sure a lot of you guys have read a petition, oh, that's weak, and then you get into the body of the detention and go, oh, okay. And then it's different. So really it's important that you really weigh that and examine it. So a parent should consider filing for a demur to challenge the sufficiency of a 300 petition that is alleging facts that, even if found to be true, are not sufficient to state a cause of action or are not clear or precise enough to enable the parent to ascertain what he or she must defend against. So there's kind of two things that you want to look at in a petition. Whether, if the petition is right, even if all the facts in the detention report are true, does it still provide a basis for jurisdiction? Or if it's insufficiently clear and you're kind of confused, you have to read the petition over and over again to figure out exactly what they're trying to get to. Those are two things that need to clue you in that a demur may be possible. And we look to WIC section 332F, and it says what we need in a petition. It's a concise statement of facts, separately stated, to support the conclusion that a child upon whose behalf the petition is being brought is a person within the definition of each of the sections and subdivisions under which the proceedings are being instituted. And it's going to change depending on which allegation, whether it's a B count, an A count, a C count, a D count. Like in criminal court, there are allegations and they have to prove every element. We kind of have to look at it similarly, where we look at not only what the allegations are, but what code are they using and where in that code is a fault in the A or the B. And we're going to go through some examples so that makes a little more sense. So some things to look for are, make sure the factual allegations are sufficiently precise to provide the parent with adequate notice. If it's something vague, like the petition that you didn't like and Justice Carlton didn't like, think about it. Think about demurring. Or if the facts alleged actually do constitute grounds for dependency, if the facts alleged, then there's no demur. If there are no facts to support it in the detention report, really think about demurring it, because nothing provided is sufficient. Or if it appears amendment may be difficult or impossible to correct the problem. A lot of times we get petitions that are written poorly, and we all know why they're written poorly, because social workers written. If there are like simple mistakes in pronouns, he instead of she, or they use the boyfriend's wrong name or whatever, that should be brought up. But that's something that's easy to correct, not necessarily demurrable. Just make sure that everyone's on notice. The court a lot of times will just, even at trial, just by interlineation change it. So that's not a big deal. So if it's something that can be easy to correct, you don't demur. But if it's something that with correction it can't be easily fixed, think about demurring it. And when do you use this? Again, when we're talking about detentions, the detention is happening during a day where we have a bunch of other cases going on. I really don't want to burden you guys more, and I don't want you guys to have one other worry, but it's really important that you recognize the importance of the demur and when to raise it. So you raise it at detention. And in Re Fred J, which was in the 70s, it wasn't raised at detention. But they gave leeway to the trial counsel because it didn't really even exist then. So how can you hold it against the trial counsel then? And in Re Alicia S, 96, also kind of allowed it to occur because it cited to Civil Code of Procedure, that it's not waived, blah, blah, blah. No big deal, you know? But what we find later on with cases closer in time, that failure to raise at detention equals ineffective assistance of counsel. Now, you know, we do have a lot to juggle, and no one wants to be found to be ineffective assistance of counsel. However, in other courts, in criminal court, I think there are trial attorneys that don't want to be Marsden. Marsden, and they try everything that they can do not to be Marsden. And dependency court, we don't like to be Marsden either, but sometimes, it's kind of like, not my problem anymore, right? In this particular case, ineffective assistance of counsel, well, you have trial counsel really pushing, like throwing themselves under the bus to free their clients from custody. Here, I don't know of any attorney at LADL that there's been ineffective assistance of counsel. But it's an instrument that can help our clients. So try and think of it that way. While we don't want to be found as ineffective assistance of counsel, if it helps our clients, it's good. And it's ineffective assistance of counsel because the appellate courts have said that we can use criminal cases govern dependency under Penal Code Section 1012, saying that failure to demur at the detention waives the defect. And in Re Justicacy, which I referred to earlier, talks about why it's important in that the petition can be poorly written because social workers write it, that if the parent believes the petition does not adequately communicate the concerns, we need to raise it right away. We can't wait for it. Because if we don't raise it and it's not addressed and we just go through it sustained and the kid is removed, and the parents fail to do what they need to do because they're unable or they're intransigent because they don't think that that should have happened in the beginning. So unring that bell and try and unwind, like I said, a year or two later after the child's in a home that's stable with a caregiver, as the child, if you're trying to get that child back, that doesn't always work. But it does, and we'll see examples of which it does. So, enough said. Now, it took me a long time. I read comic books growing up, and they would usually have a title of the comic book along with a little blurb of what it was about, and then it'd say "Nuff said." And for years I used to think, who's Nuff? Duh, it's short for enough. Okay, so just in case anyone's wondering what Nuff was, that's what that means. So, how do you use a demur? You object at the earliest possible time. You do not enter a plea, general denial or otherwise, on the insufficient allegation. However, if there are several allegations, some are sufficient, some are insufficient. On the sufficient ones, you can enter a plea of a general denial or what have you, to only those. And then what you do is you object to the bench officer, make an oral demur, say that you'll be demurring to certain counts, and request a schedule for submitting written motion and PAs, points and authorities. Amongst the materials that you were provided today are two examples, generously donated by other trial attorney on demurs that they filed. And they're on different counts, and the format that they've used are different, but both are adequate. Both can help you either win the motion or to convince county council to dismiss one or all of the allegations. So you can use that. That can be some direction. We're not going to really discuss the formatting, but you can look at that. And local rule 7.16, while we have a motion akin to demur in dependency court, local rule 7.16 really enshrines how we do it, and it uses the word demur. And it says that we need to have a date for argument on the motion 10 calendar days after, that the filing of the written demur should happen no later than 3 court days prior to that hearing, so in 7 days, and responses to your demur should be submitted to the court 1 day before the hearing. So that's basically the time frame that we have. And as you look at the samples, it's not really complicated, it's not really involved, it's just a statement of why you think it's demurrable. Now, this I'm just skipping. I included local rule 7.16D just so you can read it at your leisure later on. And before I go into that, question.
So if the department files a first amended petition and throws a little more detail in there, does that boost your demur or what?
I think so.
So,
I mean, because the first petition is dismissed, right? And the first amended petition comes in, and if there's no issue, there's no issue. If it continues to be improper, you would, again, demur and go through the whole rigmarole again.
But can't you also ask the court not to accept the second amendment?
You can, but you think a court's not going to accept it? Well, timing maybe, right?
Right.
So, but remember, if it's not a no-time waiver trial and the trial's off a while, filing an amended petition just before or at the Demurer hearing, how does that prejudice anybody? Why would they not accept it? If it was, you know, if it was a no-time waiver trial and they're trying to do it the day before, that might be something different.
Okay.
But I think that I don't think any court. Again, safety of the children. The courts really use that to do pretty much anything they want,
Right.
and the appellate court has backed them time and time again, and we'll see some examples of that. All right. Any other questions before we go into some hypos to kind of flesh out what a Demurer is and what to think about it? Okay. So hypo number one, the new baby. This one is, I think, fairly common. And in this particular case, we have in December of 2000. I'm just going to do some background to give you some information, because when we're looking to demur a potential petition, we have to look not only at the language of the petition, but also the facts. So, background. December of 2000, mother had 6 children detained from her. Juvenile court sustained allegations that the children were exposed to violent confrontations, and that the father sexually abused the eldest child. You know, just throw that in there, why not? Father moved out of the home on August 1st, 2001, but continued to pay rent. And that was after the petition was sustained. Subsequently, mother gave birth to another child in January 2002. And by the time of the trial, mother had completed therapy, a parenting class, and domestic violence course. When we say trial, it means on this new baby. And the mother's therapist believed that she had reached the goals of protecting the children. All right. So, DCFS filed a petition. Try not to go too far ahead. And the petition said that on or about January 23rd, 2002, the child is at risk for exposure to violent confrontations in the family home between the parents involving use of physical force, and that the father previously slapped the mother in the face repeatedly in front of the siblings, and the father has not attended the required domestic violence class, anger management class, and individual therapy, which places the child at substantial risk of serious physical harm. And then the J count is thrown in, that the child's also at risk because of the sexual abuse of YC. So, before moving further on this, how many people have had a new baby come in after domestic violence or fighting between parents? How many times does that happen? Really? Everyone's hand should raise. This is a very common pattern. Okay. So, what I'd like to hear is an example of both. An example, or an argument why this is demurrable and why it's not demurrable. So, who thinks this should be demurred and why? Okay, but that's a little difficult. Let's start the other way. Who thinks this shouldn't be demurred and why? Yes, Jason.
So, I mean, I think there may be an argument that the child is not at risk because of the facts you cited, but I don't think it's demurrable, because you're not saying that if these facts are true, the child is at risk. Like, I don't see how we're saying, like, oh, even if these facts are true, it doesn't state a cause of action. It does state a cause of action. If these facts are true, that the father has done these things, and that there's been violent confrontations, then the child, I don't see how that's not a cause of action.
Okay. Does anybody disagree with him? Let's get devil's argument. Let's get the devil into the room.
I mean, so this is really, sorry, this
No.
is really, this happened a long time ago, 2002, 97. And so that is a big argument in our favor to demur, because it would be potentially a due process violation. I mean, to accuse somebody of something that happened 20 years ago and say that that is going to still have an impact.
Okay, did you want to add?
Well, yeah, I was just gonna say, Dad's out of the house. I mean, yes, he's paying rent, but he's out of the house. He's been out of the house, and Mom's completed everything she's had to complete to be protective. So I'd say those are grounds for it.
But isn't that a jurisdictional argument? Isn't that saying there's no current risk?
So, first of all, just to your point, the timeline is a little closer. It's not 20 years, right? So it's, the petition was sustained in 2000, I believe.
Yeah, 2 years.
Right? So, you know, it's fairly recent, but what we look at for Demurer, one of the things is, if the facts are true, and this is a B, this is not an A, right? So again, it's really important to look at the language of the code that we're using and what's going on. So my argument would be, did you want to add something?
Let me add a glitch to it. What if after the baby's born, Mom goes to family law court and gets full custody? Dad has monitored visits on the advice of their attorney, of course.
I would say
And
that's
so,
smart.
and then is it demurrable?
But that gives more argument to why it would be demurrable.
Well, I was just going to say, as it's pled, if this is the full context of the petition under 300B, I guess there could maybe be an argument that it's a little unclear as to who's offending in this petition. I am a little unclear as to whether or not, if this is just as to Dad, although it's unclear, it doesn't say at the end the typical language that, you know, mother and father's conduct. It just sort of talks about Mom and Dad within it. I'm not clear if Mom is offending in this. If she's not, I think that that's...
Yeah, absolutely. I think that's a really important point. Additionally, to get to your point, current risk. The 300B is current risk of substantial harm, right? To paraphrase. Even if this is true, how does it communicate current risk to this new baby? Based on the facts that we provided on the other slide and this language, I would argue that it doesn't. However, just like we do in court, day of the trial, here's the last minute. So I have a last minute for you guys. What about if the social worker testified that mother made significant progress and was likely, let me change the slide, and was likely to reunify with her other children. However, she's still working through her denial as to the molest of the older daughter and has made extremely slow progress. Just moving on, her service providers for individual therapy and Safe Paths both say that she's not fully able to protect and has not even recommended unsupervised visits. And the social worker believed mother had demonstrated her inability to keep father out of the visitation situation where they could be together, even though he admitted in this particular case that there's no evidence within the 3 months. But, dun dun dun, the last minute says, oh, well, father visited the mother at the hospital when the baby was born. And he was defensive and argumentative, that he asserted at that moment that he didn't do anything to that girl. And he told mother not to sign any releases, which initially she was following his directions. That mother told the social worker at the hospital that she had arranged for the father to drive her home, even though there was a restraining order in place, then retracted the statement. She testified that she could not control father when he became angry, but said she would call the police if he came around and would not leave. And when asked whether she planned to reunite with him, her response was, I don't know. Now, some of the testimony stuff, that doesn't help us with the Demurer, because that wouldn't have been in the evidence at that point. But with these other things, Mom is clearly showing there's enough, I think, here that states, yeah, it was a while ago, but she's not proving herself to be able to safely protect from the child, right? Or from the father of the child. So, the appellate court said, again, the onus is on the parent to challenge the petition at the pleading stage. And in this particular case, it was not pled. The trial attorney did not demur. The appellate attorney tried. And they said, nice try, no. But even if we were to entertain the argument, which we will, because this happens quite a bit, we'll let you know that a facially sufficient petition does not require the pleader to regurgitate the context of the social worker's report into the petition. It merely requires the pleading of essential facts establishing at least one ground for juvenile court jurisdiction. So, the thing to take away from this case is that we have to look at we're not just looking at the petition language. We're also looking at the facts outside of it, okay? We have to give some leeway to the petition because of who writes it and how it is. Additionally, it's really important, those additional facts, because that makes or breaks your argument, whether or not that particular count is sufficient. And in this particular case, it wasn't an A, it was a B. And is there sufficient evidence? There could be, and that's where I think you're correct, Mr. Steinberg, that with those additional set of facts, that requires a trial, right? It requires a trial because there is enough to move forward, and then we have to throw it to the court to determine whether or not there's substantial evidence. Yes?
I just have a general question not directly related to this, but you know how like almost always say it's a domestic violence case and it's mom's failure to protect, and they write it as an A and a B, even though there is like no physical abuse at all to the child. Is there any advantage to demurring on the A count instead of just having it dismissed later on?
That's interesting. I have not thought about that. You would demur to the failure to protect of the mother?
Under
On the A?
Because like, yeah, they'll use the exact same language and you're like, this doesn't support an A count. So is there any advantage to demurring or just like taking care of that later on?
I don't see. So demur, I think, for me at least, two things. One, you don't want to blow it, right? And two, it's something that you're really forcing the department to reconsider and to deal with. In this particular case, what I want to do is look at the 300A count. And when we look at the 300A count, it says that any child who comes within any of the following descriptions is within the jurisdiction of the juvenile court, and it goes into the specifics. The child has suffered, or there is substantial risk that the child will suffer. Serious physical harm inflicted non-accidentally upon the child by the child's parent or guardian. Now, I understand the B is a failure to protect, but I think that here it says a substantial risk the child will suffer. And if the other parent is continuing to put that child at risk, it's there. I know a lot of attorneys say, hey, you know what, let's take mom out of the A and do the B, and tries to work out, dismiss the A entirely, and we'll do the B. We have the father there, and then the mom is failed to protect him. Does that really matter? Like A and B, that sometimes can help sell a settlement to a client. And for county council, I think, depending on how reasonable they are, they might feel, hey, we just want to get jurisdiction of this family, provide them services, and see what we can do. I think the goal of a trial counsel is to determine that there is a sufficient basis for that petition to be sustained. And I'd love to hear from anybody else, but if there's a failure to protect on an A, technically that's a B count, but I don't see it as a big error. Does anybody have any other thoughts? But it's a bargaining chip that you can use, both with county counsel and with working with your client in terms of settling, potentially. Okay, so this particular hypo has to do with physical abuse or risk thereof, and it was covered in Mr. Steinberg's training on July 26th, part of the after-hours training. That was done on July 26th. I thought it was very helpful, and what I want you guys to know is that there are additional after-hours programs that you guys can attend to learn about different issues, and the next one is August 9th on general neglect by Emily Berger, and by Dennis Smeel on August 23rd for substance abuse. So I think that this, along with all of the other programs, really help to fill in the bigger picture. It'd be helpful for many of us to attend those to get some more information. Just want to let you guys know. Okay. Hypo 2, legal guardian to the rescue. This is another, I think, fairly common fact pattern. Background, parents placed 1-year-old with paternal great uncle on January 13, 2011 while they worked to resolve their drug issues. No issues were ever raised regarding the paternal grand uncle. Paternal grand uncle was a cool cat, no problems, house was cool, no criminal background, everything's fine. Parents consented to the paternal grand uncle filing for guardianship in probate court, which was granted on a temporary basis. Probate court referred matter to Health and Human Services around April 11, 2011 to investigate whether dependency proceedings should start. And the social worker said, no problems here, we don't want to. But the juvenile court has the authority to order them to file a petition and said, hey, I want you to file a petition. And said, these three bases. First, the juvenile court gave mechanisms to parents to reunify, so it'll be better for the parents and the child. That if family reunification service did not occur, legal guardianship was not preferred permanency plan, and that child should be adopted. That's the underlying message there. And mother did not have access to legal counsel in probate court. This would give mother legal access to an attorney. How nice! The petition that was filed stated that parents used methamphetamine from 2009 to 2010, and after Kaylee was born, they placed her in the care of the paternal granduncle who was seeking guardianship. Let me add one other wrinkle there. The judge in this particular case, when asking for the petition and stating why he's finding a prima facie case, stated that if, by the time we get to jurisdiction, all the parties agree on the legal guardianship, he'll dismiss it. He or she will dismiss it. So, with that background, and with this language, who believes this is Demurer? Why?
The parents made an appropriate plan with the paternal great uncle so that there wouldn't be any risk to the kid anymore, and that says that in the petition.
And the judge even intimated that, right?
Right.
Anybody else?
So, but I think the bigger focus is that it doesn't state how the child is at risk. Like, it doesn't state a cause of action. It doesn't show any facts to allege that the child has suffered or is likely to suffer, or so even if it's true, we don't know what we're defending against. It doesn't state a cause that the child is subject to the dependency court, that the child is at risk.
Correct. That is true. And so what we do is we look at some of the things behind the petition, right? Some of the facts that are in the detention report. While the baby was born healthy, a sibling was involved in dependency court, and a 2-6 was upcoming. That parental rights were terminated for that sibling. Mother was incarcerated until October 27, 2011 because of her drug use, and mother relapsed after signing guardianship papers. Does that change your opinion at all?
No.
Does that change anybody else's opinion at all?
No.
Well, the trial court denied the motion akin to Demurer, stating that if the petition was true, in that parents use meth, place the child in the care of someone else seeking guardianship, there was a substantial risk of future harm if, big hint, if child was to be in the care of her parents. The court went on to terminate the temporary guardianship without providing notice, another big hint, and detain the child with the paternal granduncle, so kept the child with the same person that the parents had placed the child with. So, how many problems do we see here? A lot, right? So, first of all, terminating temporary guardianship. Should the trial court have done that?
No. And
Why?
the uncle should have gotten a lawyer too and been put on notice that that was going to happen.
So the uncle may have been entitled to an attorney as a legal guardian. True. Also, there's a whole issue for probate legal guardianships. In order to terminate probate legal guardianships, you've got to submit a motion and you've got to provide notice.
Isn't it different for a temporary guardianship than it is for the permanent?
Not according to this court.
Okay.
Okay? That may be, but I would argue that there needs to be that proper notice to all the family members that are required by the code, and in a time fashion that is commensurate with the 2-6 notice. That wasn't done here. Anyway, the appellate court had some fun here and said that the trial court abused its discretion when it did not consider whether a dependency petition was necessary. Why is a petition necessary here? Why should we use the resources of the department if it's not necessary? Minor was not in the care or custody of the parents. Minor was in custody of a suitable and protective guardian. Trial court even stated that he was willing to dismiss the petition and go to probate. That's an implicit finding that Kaylee was not a substantial risk. Therefore, the Demurer should not have been dismissed, and this appellate court dismissed it.
What cases are you citing?
So in this particular case, it's a KDH. This one was KDH. The previous one was NRE SO. I'll provide the numbers if they're not later on in the materials. So the appellate court continued to go on. I don't think we really have to talk about these further basis. It's fairly evident. Moving quickly to hypo number 3. Little Mr. Sunshine. So this is, again, some of these cases were back in time. So whether or not these would apply today, we really have to look critically. Because we've had other cases that have changed certain circumstances, like in RT, whether or not we need any type of parental action to sustain a BCAM, right? So that, keeping that in our mind. Background, parents adopted minor and his sister. Several years later, the parents adopted 2 more girls. And then the minor started to think that he wasn't loved as much as the other kids. When he was 9, he was placed in therapy because of behavioral problems. He was seen by another therapist later on when he became angry, and he tried to set fire to his school bathroom, other disciplinary problems. In 1998, he was referred by the parents to Children's Health Council, diagnosed, and the parents began working with future families, parent support groups, and minor began seeing a new therapist. So far it sounds like the parents are trying to do everything that they can. In September 15, 1998, minor was 13. Mother struck him in the face after a dispute over things that had been building up for many years. She admitted to slapping him, but other accounts stated that she pinned him down and punched him in the face. And the injuries characterized by the social worker that got involved, based on a report by the therapist, said that the injuries were very severe. Minor's sister stated that father physically abused the minor. Father initially denied, then admitted he lied and said he had hit the minor in the past. Parents agreed on voluntary foster care for minor. Said, okay, we don't need to go to court, take him. We'll voluntarily go into reunification plan. And they were not able to visit for 3 months due to the foster family. Minor then refused to visit the parents after that. There were a couple allegations in the plan. More facts that just state that this kid was messed up. 300B, child has suffered, there's substantial risk, you know the language. So the particular allegation here is that on or about September 15, 1998, a referral was received that the minor was observed to have a bruise on his face inflicted by his mother. The agency investigated the referral, sustained the physical abuse allegation, and offered 6 months of voluntary services, including our out-of-home foster placement with individual and family counseling. That's a paraphrase of this. Given all of the facts, what do you think about this petition? Good or bad? Well, let's see what the appellate court said. The appellate court said that they considered one triggering incident of physical abuse by the mother, one she admitted and regretted, that there were no further allegations supporting facts that suggest the serious physical harm inflicted by the mother will happen again. Mother went to therapy, she developed programs, she finished it, she was truthful, she was upset. There was no evidence that it would happen sometime in the future, which is what 300B requires. The incident was purported to be an isolated one, not likely to occur. The petition failed to allege facts to demonstrate present or future risk of physical harm. It wasn't an A, it was a B. Not enough. Demurer. B2. 6 months of services will have been provided by March 15, 1999. The voluntary services have not led to the reunification of the minor. And that the parents do not accept his skateboarding while holding onto the back of a car, listening to the musical group Nirvana, and disrupting school behavior. The therapist that has worked with the family for the 6-month period states that the minor and parents are not ready for reunification service or reunification. Demurrable or not? It's okay. This one's a little tough, especially since I threw that RT curveball at you. The appellate court in this particular case basically didn't blame the parents. Said that they were working with the department, that they didn't know that they can have visits. No one told them when they were asked and they didn't happen. That it was because the visits didn't occur, this rift started, and this behavior, there's no link of the behavior of the child being attributed to bad actions by the parents. Now, whether or not the appellate court would find the same thing now, depending on the behavior of the child. Like, for me, in this particular case, the child didn't want to go home, the child wanted to go with another family member. There's no evidence that the child was running away or hurting anybody in the home, but was engaging in destructive actions.